All right. Good afternoon, everybody. Hope you're all doing well. Thanks for your patience. Thanks for coming on the call. You were looking at my background of the city of Chicago there while we were waiting. So my name is Frank Rikas, for those of you who may not know me. My business partner is also here, Rania Jowdy, and we have our guest, or co-host, I should say, not guest, Anila Rasul. And we will be making the second of a series of webinars that we're doing regarding estate and financial planning. And this one, as it's been titled, hang on one second, is Estate Planning for Divorced and Remarried Couples, 5 Important Decisions. So we hope to provide you some really valuable information, and hopefully you'll get a lot out of it today. So Anila Rasul is a very, very good friend of ours and an estate planning and business planning attorney in our community here in Boca Raton, Florida. Very, very knowledgeable with estate planning and guidance for people who need help. And we had a great response in our first meeting, and we look like we have a very good response here for today. So she's going to go through a few items that are important for people who are in these situations to consider, and then I'll cover a couple items and then we'll wrap up. So without any further delay, let me introduce Anila Rasul.
Thank you so very much, Frank, and welcome to everyone today. I'm so happy you guys can join us for our second webinar in our 3-part series. Like Frank said, it's on examining five important estate planning considerations for divorced and remarried individuals. Today, I wanted to just start off, by, for those of you who had joined us in our first chat, we were discussing the important aspects of estate planning for newly married couples, for young families, and all the things that they encounter there. Well, today we're going to address some of the important considerations that arise when those marriages don't necessarily work out, and perhaps they are followed by second marriages. So, as we discussed before, spouses typically play a very, very important role in each other's estate plans. And this is specifically in terms of fiduciary roles, such as personal representatives of wills or trustees of trusts, or even simply being the main beneficiary of a deceased spouse's assets. But a dilemma arises, however, when the couple decides to separate or they're no longer married, since those roles now must be assigned to somebody else. My hope today is that our discussion will reveal will reveal the importance of updating and revising your estate plan documents immediately upon filing for divorce by doing simple things such as appointing backup personal representatives, or assigning guardians for minors in your will, or perhaps the need to have succession trustees named in your living trust, as well as looking into the effects of divorce on things such as durable powers of attorney or healthcare directives. Also, I might add that there's also a need to update things such as beneficiary lists on your 401ks and your life insurances and your pay on death and transfer on death accounts and things like that. So let's jump in. So one of the first considerations that I wanted to address really is just looking at the effects of divorce on estate planning in Florida. And within the state of Florida, when considering this effect, it's really important to consider the specific stage of the divorce process. And this is because Florida law specifically provides for certain protections to a divorced decedent when it comes to dispositions that are inadvertently left to an ex-spouse via a will or a trust. Basically, the law takes into consideration a scenario where, let's say, a person gets married, then they make an estate plan with that spouse in mind as their primary beneficiary or their fiduciary. Then they get a divorce, and then that person passes away without ever having altered their estate plan. Now, the purpose of this law really is to remove that absolute immediate need to revise one's estate plan after a divorce, and to prohibit an ex-spouse from making a claim against a decedent's estate and seeking an inheritance that they no longer intend. Because essentially, it serves to protect a person really from finalizing their divorce, dying the next day without having time to update their estate plan, and then their entire estate or the lion's share thereof having passed on to the person that they just divorced. So the specific statute in Florida is statute 732.507 subsection 2. And it states that a provision of a will signed by a married person that affects the spouse is void upon divorce. Well, what does this mean? Essentially, the law states that after a divorce, a will shall be administered and construed as if the former spouse predeceased the decedent, unless, of course, the will itself or perhaps the divorce judgment expressly states otherwise. And by the way, for those of you who may not be familiar with the term, the decedent means the person, or in our case, the spouse, who has passed away. And to be clear, this rule applies regardless of what role that ex-spouse played in the estate plan, meaning they could have been the beneficiary, they could have been one of the fiduciaries like the personal representative or the trustee or the surrogate, but it applies to any of those roles. And it applies the same whether we're talking about the wills or a will or a revocable trust, a living trust, or any of the advanced healthcare directives. Now, it's worth mentioning that there is one exception to this general rule, and that's powers of attorney. In Florida, powers of attorney vested in a spouse are terminated simply by filing a divorce action, as opposed to the entry of a final divorce decree that's needed with the will or trust. So that's really important to know, because there are times when people may change their mind. So to illustrate, I once represented a couple who had initiated a divorce proceeding, and they were very proactive. They took initiative and amended their estate planning documents immediately. But after some time, and just prior to the divorce decree being entered, they changed their minds and they reconciled. Now, since it's not entirely clear what would happen to that specific or that, let's say, old power of attorney in the situation, i.e. when the parties change their mind and they don't go through with a divorce, I suggested that they redraft their power of attorney just to avoid any uncertainty regarding the validity of the original document in the future. Because the last thing you would want is the need to use that document and then have the receiving agent of that document saying, well, no, it's no longer valid because you filed a divorce in between there. Now, this example that I just gave you, it raises some other scenarios and other issues that the Florida statute does not necessarily consider. For example, what happens when a person remarries or no longer wants the originally named alternatives in their will or trust to step into that role of your ex-spouse? Or more concerning, what happens if a person dies prior to the completion of their divorce? Will that to-be ex-spouse, will they walk away with all of the decedent's assets? And then what about that pesky elective share that some of you may recall that we discussed in our first webinar? So this is really why I'm always preaching to my clients. You really should always continue to examine your estate planning needs and redraft when necessary at the beginning of every big life-changing event. And that's to make sure that your objectives will always be met in the event of an unexpected death. And there's no difference, with the commencing of a divorce. It's the same thing. You see, since the law doesn't kick in and kick into effect until the divorce is final and a judgment is actually entered, a spouse remains entitled to inherit in accordance with the decedent's estate plan and remains protected under Florida, let's say the Florida homestead laws, during the proceeding itself, the divorce proceeding itself. It's also really important to remember that although Florida law will disinherit a prior spouse, it does not necessarily replace them with the new spouse. So if it's a person's intention to make their new spouse their main beneficiary and main fiduciary, they must do so by redrafting their estate plan. Now, not to complicate our matters even further, but in Florida, you can never completely disinherit your spouse without their consent, of course. Due to the elective share rules that we have, a spouse is entitled to taking 30% of an estate if they have not been adequately provided for. The hiccup with this and with this elective share is that it may be exercised regardless of any newly revised plan if a person dies prior to the end of a divorce. And this will allow a to-be spouse to still perhaps inherit more than the decedent really intended to leave them. So you may ask, well, why would I even bother amending my plan when I first filed for divorce if my to-be ex-spouse can just supersede it simply by exercising this elective share? My answer is always the same, and it's always this simple. I always advise my clients that this really should not be a reason not to revise your plan when you start your divorce, because it's always better to control what may be inherited if you pass away prior to the completion of your divorce, rather than have your ex choose for themselves. Because this is a very liberal law, and it allows someone selecting the elective share to attach to many, many different assets that a person may have. And in fact, many of my family law colleagues, they actually agree with this sentiment, and they recommend that their clients seek counsel of an estate planning attorney during their process, their divorce process as well. And when they do that, in those cases, the attorneys will end up working together and coordinating with each other to make sure that the estate planning documents and any separation agreement or any property division that's agreed to in the divorce proceeding match. For example, a lot of times we make sure that we include in the marital agreements that the parties are required to maintain a certain amount of life insurance in their policies to ensure that, let's say, child support is paid beyond the death of a parent. And then we have to coordinate to make sure that the beneficiaries listed on those policies align with the intention of all the parties. So the takeaway really is here that redrafting your estate planning document should be one of the first major things that you tackle after making that decision to file for divorce and taking those steps. Now, assuming that you have decided to redraft your estate after filing for divorce, the question then becomes, who steps in to fill those roles of your beneficiary or your fiduciaries? There's a lot of things to consider when selecting these replacements, especially if there isn't a new spouse to fill those roles, which is often the case when people choose to redo their estate plans at the commencement of their divorce proceedings or shortly thereafter. So many folks revert back to naming their parents and their siblings or their children as their beneficiaries and fiduciaries. But as we know from our prior chat, those options come with their own set of challenges. So this is where I would say a qualified and experienced estate planning attorney should be able to guide you through these challenges and help you make the best decisions for you, your family, your children during this transitionary time and beyond. And of course, it goes without saying, the earlier in the process you seek assistance from an estate planning attorney, the better the outcome. So this brings us to my second consideration, and the consideration of remarriages. Remarriages can be really tricky because usually one or both of the spouses may have to address the responsibility of prior relationships in their new plan, whether that may be alimony payments or providing for minor children, whatever it may be. And as a result, it's common that clients will turn to more than just the drafting of their estate planning documents when they're planning for remarriages, but they may also look at things like these life insurance policies that I mentioned, as well as other financial vehicles to help them protect and fund their estate planning objectives. I've also found that one of the most effective ways in which to plan or account for any unintended or problematic consequences of estate planning as a remarried couple is to have a properly negotiated prenuptial or postnuptial agreement. Little mini side note here, my family law and marital law attorney friends always tell me that the prenuptials, which are before marriage, are usually preferred because they are easier to enforce if ever contested. But these marital agreements, they allow both spouses to know exactly what will happen to each other's assets in the case of a divorce or a premature death. Now, despite not being the most romantic of topics, when used appropriately, pre and post-nups are designed to avoid conflict rather than cause it. Essentially, a well-drafted agreement precisely defines which of the couple's assets will be considered marital property and which will be considered separate property. And since to be enforceable, these agreements must be drafted based on full disclosure of all assets by both sides, they allow each spouse to know exactly what they may inherit from the other, and they allow them to securely leave certain assets to their other heirs, particularly children from prior relationships, without their new spouse being able to contest that devise. Now, an example of how prenup agreements may be used for estate planning purposes is a situation I'm currently handling, actually. And my client, she's in the process of negotiating a prenuptial agreement with her to-be second husband. Her family has owned this beautiful brownstone in New York City for a few generations, and she wishes to pass it to her adult children. So she's using, in conjunction with her estate planning documents, her prenup agreement to ensure that this particular piece of property is defined as separate property. So it'll end up with the third generation of her family rather than with her new husband in the case of a divorce or death. The provision also makes it very clear to the to-be husband in no uncertain terms that the brownstone is never going to be an option for him. It's, he can never attach to that, even if he chooses to exercise his elective share rights later on down the line if they choose to get a divorce. Now, this example, I realize, raises another issue, that a prenup agreement or any kind of marital agreement allows the parties to waive certain spousal rights that are afforded in Florida, such as the Florida Homestead Act or the elective share that I've been mentioning, both of which are very, very important concerns for estate planning purposes. In fact, Florida's homestead laws, for example, are particularly of concern to many of my divorced clients, especially when either spouse has children from prior marriages, because spouses are given very high priority under Florida's intestate succession laws, and are even highly protected when there's a will that goes against that law. So spouses get a lot of protection here in Florida. Under this law, a married homeowner or a homeowner with married children cannot devise a property that qualifies as homestead to anyone other than their surviving spouse. This applies whether or not the spouse is on the deed of the property or not. And if the married spouse has children, a surviving spouse, they can either do one of two things: either take a life estate in this property with the remainder to the children, meaning they can have it for their lifetime, and when they pass, it goes to the decedent's children, or they can take a 1/2 interest as tenants in common with the children of the decedent's children. But either way, the spouse can choose to waive this right, this this guaranteed interest in the property through signing through their prenuptial agreement and the terms of their prenuptial agreement. I find this scenario very often when there are, of course, minor children involved or children from prior marriages, and when the remarried spouses are moving into a home that was previously owned by one of both of those spouses. So this actually segues really nicely into my final consideration that I want to mention, and that's planning for stepchildren and blended families. Many remarriages result in blended families, which are families that consist of the remarried spouses as well as their shared children, and then any children from prior relationships that they each may have. With such family dynamics, the parents, i.e. these remarried spouses, they must balance leaving an inheritance for these 2 to 3 groups of children, meaning their shared children, as well as any children that they each may have from other relationships. And as you can tell, that can be quite challenging. In fact, a challenge arises when the assets to be devised are jointly owned by the couple. And in those cases, a lot of coordinating and precise drafting of their estate planning documents is needed. In fact, I drafted recently an estate plan for a couple shortly after they had gotten married. Now, the wife at the time had become pregnant with their first child together, but the husband had children from a prior relationship. They were, mostly she was, but they were concerned about the share of their joint investment account that each child would be entitled to. And it ultimately took a lot of coordination, not only between their matrimonial attorney and my office, but also between the husband and his ex-wife regarding what would be left to their shared children, to ensure that all of the children would be adequately provided for at the end of the day. So after several months of back and forth, we finally all came up with this equitable division of assets that everyone was really happy with. Now, that was a really good outcome involving a group of very cooperative adults. But as you can imagine, significant challenges can be encountered when we're dealing with parties who don't necessarily agree. In fact, one of the greatest challenges of an estate planning attorney in these situations is working around the family dynamics of these situations. And it's especially problematic when there's animosity between children from prior marriages and a new spouse, or a new children from the new marriage. And in fact, these challenges are quite amplified when we're dealing a lot with the ages of the party. For example, when the age of the new spouse may be close to or less than the children of the prior relationship, which happens more often than you would think. Many of you may recall the Anna Nicole Smith case from several years back. But as I've always preached to my clients, it goes without saying that leaving behind a plan that may be less than perfect for all those involved far supersedes the outcome of not having a plan at all, or having a plan that's incomplete when you're dealing with blended families. So I encourage my clients to consider the following when drafting their estate plans to account for their blended families. And that list starts with looking at the need of all of those you intend to leave your assets to. So, consider what is the need of, let's say, your established adult children versus your minor children that you may have who have not, started careers or anything like that yet. 2, what are their expectations? Have you been promising for years and years certain assets to go to certain of your heirs? 3, do what's fair. If that's your objective is to do what's fair, it'll make it a lot easier on yourself. However, I've come to learn that this is a pretty subjective determination, because no one is ever 100% satisfied with the outcome, regardless of what it is. And then finally, explore other vehicles, not just, have your estate plan and your estate planning documents clearly state your intentions, but explore other vehicles such as life insurance policies, as well as other financial investment products to properly fund the estates, to equalize what's being devised in efforts to ease any of the existing tensions amongst the family members that you may leave behind. So as you can see from what I've mentioned here, there is quite a bit of overlap between family law considerations and estate planning considerations when dealing with divorces and remarriages and blended families. And what I've learned over the years is that to successfully accomplish both these objectives, it requires a lot of cooperation and prioritizing by all the parties involved. So once again, quickly to recap my portion of this list of the important considerations from the estate planning perspective when contemplating divorce, it's one, the need really to redraft your plan even temporarily immediately after filing for divorce. Two, the use of marital agreements to assist with the estate planning process. And three, the need for coordinating amongst the spouses, the attorneys, and even perhaps their exes when dealing with blended families, because really at that point, the children are of utmost importance. So with that, it brings me to the end of my portion. I hope you found some relevance and some value in that information. And now I will turn you back over to Frank and Rania. Frank, sorry to interject, but I think you may be muted.
Sorry about that, everyone. I apologize. Thank you, Anola. That was a great presentation. Really, really good information and very valuable. I hope we all got a lot out of it. So in conjunction with the theme, which is estate planning for divorced and remarried couples, I want to let everybody know that my business partner and I, Rania Jowdy, we are certified divorce financial analysts, and we play a role in the divorce process with couples, or typically it's one of the couples, one of the divorcing couples, and helping them plan for their future. And we may be involved in the actual proceeding, or we may be involved after finalization. And there's always a lot of topics that get discussed. And I do want to talk one specific topic, and then I want to get into an actual area of something that I think is extremely important for them. So the area that is extremely important is long-term care planning. And with long-term care planning, it can strike at any age. There's really no age for long-term care. It is no longer a old age dilemma or an old age problem. You can have a healthcare need whether you're 30, 40, 50 years old, or obviously when you certainly become older, as maybe some of you are experiencing with a parent or someone else that you know. But the statistics, and I want to make sure, Anila, can you see the screen? Are you able to see the screen?
Yeah, I can see you.
Okay, I've got some information up there, so I want people to be able to see it. So, how about now?
No, I'm still seeing you. I don't know if any of our guests perhaps can see.
I think you might need to give me back control. Let me see. Well, All right. I apologize. So the statistic for long-term care insurance is pretty significant. 70% of people will need some type of long-term care service and support by the time they're 65. And it's a dilemma in the world that needs to be addressed. And honestly, whether you're single, divorced, married, it really doesn't matter, but it really comes into play a lot with divorced couples because now they have potentially inherited or received some assets. Their world is much, much different than it was previously, and now they're alone. And who knows if they're going to find another partner, have another partner, get remarried. So one of the things that becomes a concern is protecting your assets in the event of a healthcare event. So one of the ways to do that is by purchasing long-term care insurance. Now, there's two ways to purchase coverage, and I don't want to get too deep into either one of them, but you could certainly buy a standalone policy which covers long-term care, right? But the biggest argument that we sometimes get is, I've paid for the coverage. If I don't need it, what happens? And yes, that is a very, very valid point. So what has happened over the past 10 years is many insurance companies now have added long-term care insurance as a rider to their policy. So you have a need for life insurance because you want to leave life insurance to children or your new spouse, as an example, since we're talking about remarried couples. So you attach the rider to your life insurance policy, and now you have the best of both worlds. You make one payment, you have your life insurance, and then you have, if you need it, your long-term care insurance. And we are seeing a very, very big, I'll call it uptick in planning for people to protect their assets from this high cost of care situation and to protect their assets. You know, you work hard, you work long, and you accumulate all of these funds, and it's very, very difficult to watch it just, you know, I don't want to say be wasted away because that's really not a good way to say that, but to be used for healthcare when you can transfer the risk to an insurance company. So one of the things that we do as advisors is we work with the couples or an individual, and we show them the various options, and then we try to guide them to what is best for them. To be perfectly upfront, in most cases, it makes sense for the life insurance purchase with the long-term care rider attached to it. That seems to be not only the most economical, but the most efficient way of doing it. Additionally, one of the better parts of it is that when you qualify to receive the long-term care benefit, the premiums that are needed to continue the life insurance policy are no longer taken. Matter of fact, the insurance company won't take any more money at that point. So now you've relieved yourself of the burden of having to pay premiums. So that's a very good feature. And everybody's situation is certainly different. So there's various ways and various amounts for you to purchase your coverage. But I will say that people have now, when they purchase it this way, have the comfort of knowing that their assets are protected. If they need care, whether it's at home, in a nursing home, adult daycare, assisted living, that they can use the life insurance policy's death benefit, because you're getting an advance of the death benefit to cover the cost of care, and you'll be able to protect and preserve the assets that you have. It really depends too on how old you are and how much coverage we want to start with. So it's a very detailed process that we go through, but we're finding that more and more people are looking at this as a very valuable option, as opposed to self-insuring, which it would take you an awful long time to catch up if you have very few assets or you're expecting to live off your retirement assets. And that's the issue that becomes into play here. You know, you have either a 401k or you've inherited an IRA, or you have other assets from the divorce, or even if it's your own accumulation, you want to use that for retirement and for living expenses, not for healthcare coverage. So we feel that this is a very, very important part. And again, I have to say that for people who are divorced, and we see it a lot in gray divorce, some of those people will not be remarrying, and they are going to be potentially without a partner, and maybe the children are not close. So it becomes a dilemma, and we feel very, very strongly that this is one way of covering that situation and protecting yourself. The other thing I want to talk about, and I'm going to try and see if I can share my screen because I would love for you guys to see this. So bear with me 1 second. All right, how about now? Can you guys see, can you see the screen by any chance? No. Okay, I'm not really sure what the issue is. All right, bear with me a second. I'm trying to share the content. How about now? Are you able to see the screen now? Anyone?
No, it should be next to your open share tray. If you click on open share tray next to the mute button.
Yeah.
And it should come up with a bunch of screens underneath. Do you see that? Like a bunch of little windows underneath. You can click on one of those windows and then it should share.
All right, let me try it again.
You have to click here.
So share content. Sorry, folks.
Where is the? Okay, so click on that. Yeah, that's it.
How about now?
It should work. How many screens do you have open? Let me see.
Not quite yet.
No, I may have had too much stuff open.
Can you go back to? Can you go back here? Here. Click on this.
Got it now?
Yep.
Well,
Okay.
something's coming up.
We can see it.
There we go.
All right. Sorry, everybody. So this is a program that was designed by an equitable advisor. Oh, that went away. Uh-oh. Okay, I'm going to have to do it without. Sorry. I don't know what happened here. Anyway, we have a program that is called Asset Map. I'm going to try and get it back. No, it's not going to work. I'm sorry. So we have a program that is called Asset Map, and what Asset Map is our planning tool that puts everything on one piece of paper, showing you all of your insurance products, all of your investment products, your Social Security, your house, your savings, and it's all there for you on one document. And the document is something that we update on a regular basis. So especially for someone who has just either remarried or become divorced, that is the best time to get yourself organized. So we can have a planning session and sit down and see where you have, what you have, see what the values are, and put it all together. In addition to that, the program has an item called target maps where we can actually project various scenarios in your life. Do you have enough life insurance? Where are you with long-term care insurance? What do you have for disability insurance? And also, very importantly, where are you for retirement and how much of it is funded? So the planning tool is very, very useful. People really enjoy it. What I'm going to try and do is send a link to those of you that are on the call so you can actually fill one out for yourself, and we can show you exactly how it works. But again, after divorce, or especially at remarriage, it is definitely a time to get yourselves organized, and that's what this planning tool does. And I really can't think of a better time for you to do that at that point. So with that, I think we can wrap up. I know that there probably are some people who have questions, but because this is a very, very sensitive
Sorry, Frank. I think you you cut off on my end, so I apologize for that. But I didn't hear your last words. Were we taking questions at this point? All right, guys, and this is what happens in the age of technology. So, unfortunately, Frank's computer conked out on him in the middle of talking to us, and that's why we couldn't hear him. So, I do apologize for that. If there's anyone out there who has questions, I will gladly take the questions related to what my part of the presentation. But if not, I appreciate you all coming, and please feel free to reach out to any of us, Frank, Rania, and myself, if you have any questions that may come up in the future regarding this topic.
Thank you, Anila. Good job.
Thank you, Lee. Thanks for joining us. All right, then thank you so much, guys. With that, we'll end our conference. Thank you all for joining us today. Bye-bye.
Thank you.
That was